This presentation will be made in regard to plant breeders' rights and how you as a farmer may choose to use these rights to benefit your farming practices. So what are plant breeders' rights? Plant breeders' rights are the exclusive commercial rights over a registered plant variety. In Australia, plant breeders' rights are governed by the Plant Breeders' Rights Act 1994 of the Commonwealth. Our domestic legislation conforms with the International Convention for the Protection of New Varieties of Plants. This Act is administered and enforced by Intellectual Property Australia. To obtain plant breeders' rights under the Act, an application must be made to the Secretary of the Department. The application must include a brief description and/or a photograph of the plant variety. Propagating material must also be deposited with an approved genetic resource centre, and a specimen plant must be supplied to an official herbarium. The Secretary will accept the application and grant plant breeders' rights over the plant variety if no other application for the same thing has been registered on an earlier date. It must also comply with the formal requirements under the Act. Some of these formal requirements include listing the name and address of the applicant, the name and description of the plant variety, the plant variety's location, the names of the parent varieties used to breed the plant, and the way in which it was bred. The new plant variety must also be distinct in nature. The average time taken for plant breeders' rights registration is 2.5 years from time of application to successful registration. But this is dependent on the length of the growing trials required for each plant species. To give an example, the length of a growing trial required for wheat is 2 years, and similarly, the growing trial required for rose varieties is 2.5 years. Fruit varieties such as apples and mangoes require a longer growing trial of 5 and 10 years respectively. It is also important to note that there are various fees required to be paid throughout this process. They include an application fee of $345, a separate fee payable to a qualified person you employ to oversee your growing trial, an examination fee of $1,610 per single application, a certificate fee of $345, as well as an annual online renewal fee of $345 payable on the anniversary date that your plant breeders' rights were first granted. Under Section 43 of the Plant Breeders' Rights Act, there are certain characteristics required to be certified before a plant variety will become registrable. Firstly, it must have a breeder. The breeder may be an individual, a group of individuals, or a company body if it were bred by an employee. The plant variety must have been developed with some level of human intervention to constitute breeding. Secondly, the plant variety must be distinct. This means that the plant variety is clearly distinguishable from other plant varieties at the date of filing the application. The plant variety must also be uniform. A plant variety will be deemed uniform if, in allowing for variations caused by plant propagation, it is uniform in its characteristics. The plant variety must also be stable. That is, the characteristics of the plant remain unchanged after repeated propagation. The last criteria requires that the plant has not been exploited or has only recently been exploited. A new plant variety is one which has not been sold with the breeder's consent earlier than 1 year in Australia or 4 years for overseas varieties. The allowable timeframe is extended to 6 years for overseas tree and grapevine varieties. It is important that I make special mention of this 12-month grace period. This operation of the grace period allows for some market testing before registering the plant variety. However, there is a danger that in delaying application for registration, another breeder will secure an earlier priority date and you will not be protected as the plant breeder. As you can see, successful applicants will be given exclusive rights in relation to the plant variety. This includes the production and reproduction of the plant material, the propagation of the material of the plant variety, harvesting, the offering of the plant material for sale and selling the plant material, the import and export of the plant material, the varieties essentially derived from the protected variety, varieties not clearly distinguishable from the protected variety, as well as the varieties whose production requires the repeated use of the protected plant variety. Essentially derived varieties, or EDVs, are a plant variety derived from the protected variety that is slightly distinguishable from the initial variety, but is predominantly derived from and exhibits the characteristics of that initial variety. Now, once that is understood, it is helpful to go through an example of how an essentially derived variety may be applied within a plant breeder's rights scenario. So for example, if farmer A breeds a new plant variety called A1 and obtains plant breeder's rights for that variety, farmer B may use A1 to create a new variety called B1 and seek plant breeder's rights for that variety so long as B1 is neither essentially derived nor a dependent variety. However, if the new variety B1 is found to be essentially derived, farmer B can still retain the plant breeder's rights. However, these will not be exclusive. Farmer A can also exercise these rights, as B1 was essentially derived from their variety A1. Farmer B can now only exploit the plant breeder's rights held in B1 with Farmer A's permission. Farmer A may choose to grant permission to commercialise B1, but seek royalties on the plant variety as compensation. In terms of seeking royalties as compensation, endpoint royalties, as defined in the Act, can be collected on propagating materials, harvested materials, products made from harvested materials, essentially derived varieties, and dependent varieties. Endpoint royalties apply to the outcomes of exercising the breeder's right to make the harvested material. This is said to encourage the quicker adoption of the new plant varieties and to also support plant breeding programs. It is also said to encourage investment in crop improvement. There are 4 listed exceptions to plant breeders' rights granted under the Act. The first of which is private non-commercial acts. That is, that rights do not extend to acts done privately and for experimental or non-commercial purposes. Secondly, breeders' rights do not extend to acts done for breeding other varieties. This includes acts done in relation to new varieties bred from breeders' varieties unless they are EDVs, indistinguishable, or require repeated use of protected variety for propagation. That is, they are dependent varieties. Thirdly, there is a farm-saved seed exception that applies where farmers have planted a protected variety on their own land and wish to use the product of their harvest for future propagation in their own land. The last exception, as authorised by law, applies where a person is authorised by a law of either the state or commonwealth to do an act that would otherwise constitute an infringement. Once registration has taken place and full protection has been awarded, plant breeders' rights last for 20 years. However, for trees or vines, this is extended to 25 years. It is important to note that once your plant breeders' rights expire, are surrendered, or you revoke them, the variety becomes a part of the public domain and is therefore publicly available. Now that we have established what rights exist under the Plant Breeders' Rights Act and how long they endure, it is important to know how they may be infringed. Infringement occurs when something is done which only the right holder is authorised to do. It can also include falsely claiming to have the right to do something, or using a protected plant variety's name for another plant or variety. An action to enforce plant breeders' rights may be commenced in the Federal Court of Australia, although the High Court does have jurisdiction as well. Apart from civil federal court action to recover losses incurred by infringements, any intentional and reckless infringement of a plant breeder's rights may attract a criminal penalty of up to $50,000 for individuals and $250,000 for corporations. So why should you, as a farmer, make use of plant breeders' rights? Plant breeders' rights will give you, as a farmer, a commercial monopoly over your plant variety for a period of time. This is an opportunity to commercialise the variety yourself or through a contractual arrangement, such as licensing a person or organisation. For the protected period, you are the only person who can do this. Companies can enter into licensing contracts knowing that their investment will be protected by plant breeders' rights. It is also in the public interest and the aim of the Act that plant innovation is encouraged. It will also develop the industry faster. Many plants become susceptible to disease and predation within 6 to 10 years of general use, so arguably, plant breeder rights encourage investment in research and design of new plants so as to edge out any insects and fungus that may try to overcome the characteristics of the plant. At the end of the day, this will improve the quality of the plants produced. It is also important to flag any downfalls of plant breeders' rights and what problems these may cause. It can lead to exploitation of developing countries, as bigger companies try to monopolise a plant variety that was originated in a developing country and sell it back to them at an inflated price. It can also increase the cost of seed and encourage unhealthy practice within the industry. It may also reduce genetic diversity. So what happens if you choose not to make use of plant breeders' rights? You may choose to keep your plant variety a secret or make it publicly available. In making it secret, it's important to assess the risk and consequences of someone obtaining your variety without your permission or independently breeding a very similar variety. In terms of making it public, you can openly use and publish details about your variety. This will prevent someone else obtaining a plant breeder's rights or a patent for the same thing, but can also allow your competitors to freely use your variety for their own benefit. Other issues surrounding plant breeders' rights are plant quarantine and biosecurity and the prohibition against the use of a variety of food. That is, it's important to be aware of any legislation that may prohibit the growing of that variety of plant for health reasons or because it is a noxious weed. So that concludes the end of this presentation, and I hope that it has been valuable in determining whether you as a farmer will make use of plant breeders' rights in Australia. If you have any further questions, please refer to the sources listed in the bibliography. Thank you.